All right. Um, so to begin with, I'd like to start by acknowledging that we're meeting on Aboriginal land today. I'm in our office in Surrey Hills on the land of the Gadigal people of the Eora Nation. I'd like to pay my respects to elders past and present and extend those respects as well to any Aboriginal or Torres Strait Islander people here with us today. So a little bit about who we are. Um, Welfare Rights Centre, we're a community legal centre that specialise in social security and family assistance law. So all things Centrelink decisions and the complicated body of law that makes up how it all works. We help people who have problems with Centrelink. There's all sorts of problems that come up that we assist with. We give people free legal advice, information. Um, Sometimes we're able to represent people as well in their appeals, either through to the internal review stage at Centrelink or externally, sorry, to the Administrative Review Tribunal. Um, we also run a First Nations access program and do outreach with the Aboriginal tenancy list at NCAT, and our CEO, Catherine's currently doing an outreach in Dareton in regional New South Wales. We're a member of a couple of peak organisations as well. The first is Economic Justice Australia. They're a peak for social security law specialist community legal centres throughout the country. We're also a member of Community Legal Centres New South Wales and Community Legal Centres Australia. A lot of the work our centre does is particularly used by Economic Justice Australia for a lot of their law reform and policy reform work that they do. We'll often feed up case studies to them, or if there's issues that we're identifying on the ground in our day-to-day work, we make them aware of it, and they produce some fantastic reports. But I also wanted to let you know that today's session, it's just general information. It's not legal advice. And if, anyone, clients in particular need legal advice to contact us to see if we're able to give them any advice. Like I said earlier, there will be room for questions throughout the presentation. Try and keep it general though and not too specific, and don't um, go super in depth into anyone's personal circumstances because I'm not going to be able to answer it because it might be giving advice. It's also a complicated area of law with a lot of different moving parts, so we might not be able to answer everything today with how complicated it can be and the number of people that are present, but we'll try our best to get through what we can. And so, a little bit about what today's session, really the aim is just to give a bit of an overview of our social security system and some of the common types of issues that we see. Really, it's to give you an orientation point, make you aware of some of the things that can come up. Um, it's not going to be able to go through um, every type of issue that could arise. Really, it's just focusing on some of the common areas where we see problems and provide assistance. It's a bit of a time of change with a lot going on as well in Australia's social security system at the moment. There was recently the Robodebt class action appeal settlement with an additional 548.5 million awarded to um, members of a class action. As well, there's been the Commonwealth Ombudsman's report into the targeted compliance framework with mutual obligations. There's been the recent federal court decision on Centrelink's income apportionment that's been a real issue at the moment. And then as well, there's the quite wordy Social Security and Other Legislation Amendment Technical Changes Bill, which this is before Parliament at the moment, proposes a number of changes to the Social Security system, particularly with Something I'll touch on briefly later, but special circumstances debt waiver, and one of the requirements that a person hasn't knowingly misled Centrelink. With our advocacy work and the advocacy work of Economic Justice Australia, we've been pushing for some changes around that for some time, particularly to better address circumstances where a perpetrator of family domestic violence has lied to Centrelink or perhaps forced a victim survivor to lie to Centrelink, and often after the relationship breaks down or they manage to escape, they're stuck paying a debt that they may not be able to get waived with how the law is currently written. So, um, yeah, it's a bit of an exciting time, and it'll be interesting to see how those changes develop. All right, but to begin, I just wanted to give a bit of an overview of some of the common issues that we see day to day in our work. Um, there's all sorts of things that pop up. It can be delays with processing applications. We often see lengthy delays with payments like the disability support pension, for example. Um, People might have issues claiming payments. For example, they might not have the right form of ID or may not have any form of ID, and can run into issues there. People who have been rejected for a payment, or perhaps they've been receiving a payment and for some reason it's been cancelled. Excuse me. It can include things like people having issues with their rate of payment. Perhaps Centrelink allege they're in a relationship when they're not, or they might believe that they're not. Um, or, um, excuse me. It could be a number of other issues, really. It's a complicated system with a lot of things that can affect the amount of payment you're getting. It can include things like your income, your assets. Um, we see a lot of Centrelink debts as well. I'll go through and explain a little bit more about what debts are towards the end too. And we often help people navigate and give them advice on the appeals of a review system. So first of all, what Centrelink payments are there? Australia's social security system, it's different to a lot of other social security systems throughout the world. Many others are based on contributions to their system that people make throughout their working life. Australia's isn't like that. Instead, it's based on um, a lengthy system of rules and law that sets out whether someone is eligible or whether they're not eligible for a payment. This slide's just a bit of an example of the system. It's massive. The Centrelink system delivers payments to millions of people throughout all of Australia. Um, and with a number of different payments that make up this system can be incredibly complicated. Each of those payments often have their own specific eligibility criteria that people need to meet to be able to receive them. And in such a large system as well, there is human error. Mistakes can happen. And because we're often dealing with people's income, it can feel personal. Now, to start off with, I'm just going to go through a couple of the payments and some of the common criteria for them. Um, a lot of the payments are set up around sort of themes. For example, here we've got the working age focused payments. So these are typically people that um, can work or might be looking for work, or with parenting payment here might be raising children instead. There's age requirements for some of these payments. So, for example, with youth allowance as a job seeker, a young person might be eligible for that if they're 16 to 21, looking for full-time work, or if they're undertaking approved activities. So that could be meeting their what are called mutual obligation requirements. Then once that person turns 22, they might be eligible for job seeker payment instead, which is the main income support payment that I'm sure a lot of you have probably heard of. Um, Again, that's paid for people who are looking to work or looking for work, sorry, or they might not be able to due to some sort of temporary incapacity or some sort of exemption they might have from those requirements. Excuse me. There's also another payment here that we see every now and then, special benefit. This is quite a different payment to the others. Normally, someone's only eligible for it if they're not eligible for any other Centrelink payments, and there's a number of other criteria they need to meet as well. Um, excuse me. It's colloquially sort of known as the payment of last resort for Centrelink payments. It can have mutual obligation requirements as well, so people who are receiving special benefit might need to engage with a job agency, apply for a certain number of jobs, and meet their points for meeting their mutual obligations. Then we've got payments for students as well. There's two main ones here, which is youth allowance student and Oz Study. Youth allowance is for students that are 16 to 24, whereas Oz Study is for students that are 25 and over. Um, there are some complicated rules around youth allowance and Oz Study as well, like what happens if you're a student who turns 25 and you've been getting youth allowance. Instead of moving over to Oz Study, if you're still studying the same course, you continue to receive youth allowance until that course is finished. Um, like a lot of these other payments as well, they have lengthy criteria around whether someone's eligible. This can include taking into account things like someone's income, their assets, whether or not they're studying full time. There are some rules that can allow people to receive these payments if they're studying part time, but they're very limited in when they apply. I'm not going to go through those in detail as well today. It's really just a bit of an overview. There's also another study payment, AB study. This is a payment specifically to assist Aboriginal or Torres Strait Islander students with the costs of studying and training. AB study is quite different to all of the other Centrelink payments like youth allowance and Oz study as well, in that it's not within the Social Security Act. Instead, it's under an AB study policy manual that sets out how it works. This is a lengthy PDF document that explains the AB study system and whether or not people are eligible for AB study payments and the criteria that they need to meet to be able to receive AB study. AB study is quite different as well in that there's a number of different payments that make up AB study. It can include help with things like the cost of travel, school fees, living costs, if you're boarding and have to live away from home to be able to study, as well as things like, books, stationery, etc. Here's a bit of an example about the AB study system and how complicated it is. On the left is the list of payments that make up AB study, and on the right is the awards that determine which payments within AB study that people are eligible for. We've got a whole separate session dedicated just to AB study. It is a very complicated system of payments, unfortunately, and it can be quite difficult to navigate. As well, there's also what are called pensions. These are different to some of the other income support payments. These are typically paid to people who are unable to work, either due to age, perhaps they're retired, or due to disabilities that prevent them from being able to work. With the age pension, people aren't eligible for it until they reach 67. Um, there's no job search requirements for the age pension, so you don't need to look for work. It'd be a bit of a shame if you retired, started getting the age pension, and then got told you needed to meet job search requirements. It'd be quite unfair, and people would get rightly pretty angry with that. Um, like many of these other payments as well, it does have income and assets tests that apply, and I'll go through and explain a bit about those soon. Generally, they are higher amounts than other payments like JobSeeker. With the disability support pension as well, that payment's quite complicated, and there's a long list of eligibility criteria that people need to go through to be eligible for the pension. You need to meet criteria around whether you have a physical or psychiatric impairment, whether it's reasonably diagnosed, treated, stabilized, not going to improve within the next 2 years. Um, Then it's assessed against what are called impairment tables, where Centrelink look at how your conditions affect you on a day-to-day basis. Then they also look at whether you're able to work 15 hours or more a week within the next 2 years. And depending on how many points you get assigned to your conditions, you may need to complete an additional requirement on top called a program of support. And what that is it's engaging with a job agency for 2 years in the 18 months before sorry, 18 months in the 2 years before you applied for the disability support pension. We've got a bit of an example of the long series of steps that people need to go through to meet the criteria. Excuse me. So, yeah, the disability support pension, it's incredibly complicated and can be very, very difficult for people to navigate. There's also other provisions that can apply around the disability support pension too, like perhaps someone might meet all of these criteria, but they're working for a well-paying job and their income might be too high, or they may have assets that are too high to receive the pension. So a lot of these other potential issues can interact with the disability support pension as well. There's also payments for people that are caring for another person, people who aren't able to work full time or might only be able to work part time because of their care requirements. Um, there's two main ones, carer payment and carer allowance. They do have different eligibility criteria around the level of care that you need to provide to another person. And they do have other criteria as well. Carer payment does have income and assets tests. Carer allowance, on the other hand, it's got a very, very high income limit where you can receive it if you earn under $250,000 a year. It's a bit complicated with how Centrelink assess though someone's income for care allowance and also for the family tax system. There's also a number of payments for families, often known as the family assistance payments. There's a family tax benefit Part A and B. Um, Family tax Part B is paid regardless of how many children you have at a base rate, depending on how old your youngest child is. Family tax A instead is paid per child. There's requirements for these as well about the percentage of care that a child needs to be in someone's care to receive these payments. Typically, as well, with family tax, only one member of a couple can get this and parenting payment if they're looking after children, if both people aren't working, for example. Um, they also do have income tests. They're very different to the other tests for job seeker, for example. As well, there's another payment here, childcare subsidy. Childcare subsidies to help with the costs of children attending childcare. Um, it has some common requirements with family tax, particularly around the child, percentages of care that a child needs to be in someone's care. Um, Income tests can apply as well. And lastly is paid parental leave. Um, Paid parental leave is incredibly complicated and has its own act that sets up how this payment works. Um, Typically, it's paid to people though who have stopped working because they've just had a newborn child and need to leave work to be able to care for them and raise them. It has its own series of eligibility criteria and rules that set up how it works as well. All right, but start at the beginning. How do you even claim a Centrelink payment? Well, there's a couple of different ways to apply. First of all, you can apply online through MyGov. This can be particularly difficult though for older people, people who are newly arrived migrants in Australia, or people that might have low or no digital literacy. People can also apply for payments over the phone, or for some payments, completing a physical form and lodging it in person at Centrelink or sending it in by the mail. Not all application forms are available to download, though, and print out and complete. For example, I believe carer payment is one that you can't physically complete. Or sorry, but you can't download and print out and then complete. It's one that you need to request from Centrelink. Often it can be quite onerous and lengthy to complete an application form. I know that the disability support pension form, for example, it's incredibly long. It's quite an effort to go through. And you can also lodge supporting evidence after you've completed the application. Generally, though, once you've lodged an application, you can only be back paid from the date that the application's lodged. You normally can't be paid at an earlier point in time. Say, for example, if you stopped working and then didn't apply for Job Seeker for another year after you stopped working, you'd only normally be eligible from the date that you actually lodged the application. You wouldn't be eligible from the date that you stopped working. There are some limited exceptions that can apply though. For example, family tax benefit lets you lodge an application for a past period, typically the previous financial year. When you're lodging an application for a payment, there's also a number of ID documents that you need to provide to prove who you are. Typically, there's three categories that Centrelink require. First of all, it's what they call a commencement document. So this is something like your birth certificate, your visa, your passport, citizenship certificate, things like that. Then there's primary documents. These are your license, proof of age card, student ID card, etc. Um, as well as what they call secondary documents. These can be things like a bank card, kids' birth certificates that have you listed as a parent. It could be your lease, rego papers, utility bills, Medicare card. Depending on what payment you're applying for, there might be all sorts of other things you need to provide as well. Typically, you'll need to provide a copy of your TFN, your tax file number. Uh, Normally, you're required to provide copies of bank statements as well, so Centrelink can assess what your assets are, whether you have any source of income. If you're a sole trader, you might need to provide tax returns for your business or profit and loss statements. If you're in a relationship, you might need to provide a form that sets out the details of your relationship. Or if you're living with another person but you're separated and living under one roof, you might need to fill in a form for that as well. Can be required to provide other things too, for example, separation certificates if you've recently stopped working, um, evidence of study if you're applying for a student payment, or medical supporting documents if you're applying for the disability support pension. An issue that we see every now and then as well is what happens if you don't have any form of ID. So, for example, let's say someone doesn't have a license, they might not have a passport, or they might not have a copy of their birth certificate either. Centrelink normally requires the person to try and prove their identity. Um, you can ask Centrelink for assistance. They do have what they call alternate ID rules. They can grant a payment for 2 fortnights if there's a minor issue with someone's ID. And the idea there is to try and give the person some support and give them a bit of breathing space to try and sort out whatever their ID issue is and provide a copy of their ID once they get it to Centrelink. There's also specific alternate ID rules for Aboriginal and Torres Strait Islander people as well, um, where this alternate ID confirmation form can be completed by what they call an authorized referee. This is typically someone in the community that can fill out this form. It can include something like a school principal, a doctor, or, for example, the chair or secretary of the local Aboriginal Land Council. And so, just a bit of a case study here. Um, it can be a difficult system to navigate, and with how complicated it is and the series of laws that set up how it works, it can often take time. to navigate and try and work your way through it. So, for example, here we had Susie, a previous client who'd been surviving on a low rate of age pension for over a year. Her pension had been reduced because she'd received a small insurance payment after her husband had passed away. She was quite distressed and in financial hardship when she contacted us. She tried to contact Centrelink several times to figure out what the problem was, but nothing had changed and her rate of payment had stayed the same. Um, we spoke to Susie, talked about her circumstances, her income, assets, that sort of things, and came to the view that she was receiving the wrong rate of payment and that her payment should have gone back to the full rate um, some time ago. We contacted Centrelink on her behalf, and it was a really quick turnaround. Within 3 days, Centrelink had looked at it and resolved her issue. They'd put her back on the full rate of the age pension, and then she'd received back pay of more than 10 grand. And so I'm just going to go through here as well some of the common rules across most Centrelink payments. Um, do have to qualify here, some of these rules might not apply for every payment. Again, it can be a bit of a messy system. So to start with, you typically need to be a permanent resident, an Australian citizen, or hold a specified subclass of visa to be eligible for Centrelink payments. You also need to be in Australia when you lodge the application. When you apply, you typically need to intend to live in Australia for the next 2 years after you've applied as well. I've seen this often be an issue as well with people who um, have lived overseas for some time. And they come back to Australia once they turn age pension age and then apply for the pension and are told that they need to stay in Australia for the next 2 years. Otherwise, they're not going to be able to receive the pension when they leave Australia. You also need to be what Centrelink considered to be an Australian resident. Under social security law, they've got a series of factors they look at to decide whether or not someone is an Australian resident. So this can include things like how often you've travelled in and out of Australia, your connections to accommodation, where you're living when you're in Australia, your ties with family and other relationships here and overseas, your business and financial ties, whether you're working in Australia, whether you have assets here, and anything else that could be relevant in an individual's situation. But going back to that first point with the permanent resident, citizen, or holding a specific subclass of visa, the visa categories essentially determine whether or not you're eligible for Centrelink payments to begin with, and it is very rigid and strict. There's no broad special circumstances rule that allows you to get around the visa categories. So from what we can see in this slide here, if someone holds a bridging visa A, they're not eligible, they're not residentially qualified for any Centrelink payments. Whereas someone who holds the bridging visa F, the second last one, they might be eligible for special benefit, family tax benefit, paid parental leave, and a healthcare card. Unfortunately, if you're not on an eligible visa, there's pretty much no way around it. The only exception that's very limited is for childcare subsidy to help with the cost of paying for childcare for children. So we've got a bit of an example of this here as well. Yuriko holds a subclass 461 New Zealand Citizen Family Relationship Visa. She married her husband who had permanent residence in New Zealand. They've got a 4-year-old kid as well who has dual Japanese and New Zealand citizenship. They all moved to Australia some time ago, and she'd been with her husband for 12 years. Um, some of that time they'd lived in Australia on several occasions and had recently, within the last 5 years or so, moved permanently to Australia. Unfortunately, Yuriko experienced family and domestic violence throughout the relationship. With help of some support workers, she was finally able to leave the relationship. Unfortunately, though, she couldn't leave Australia with her child. She was prevented from leaving the country with them. She'd been waiting months for a family court hearing about the custody of their children. Unfortunately, because of Yuriko's visa subclass number, this 461 New Zealand family visa, she wasn't eligible for any Centrelink payments. She couldn't access parenting payment for herself, special benefit for herself or her child, or family tax benefit. Um, Unfortunately, there was nothing we could do to assist Yuriko to get on a Centrelink payment. All that we could recommend was that she contact a community legal centre specialising in immigration law for advice on a visa status and whether there were any potential avenues for permanent residence that might allow her to access a Centrelink payment in the future. There's also a number of what are called waiting periods that can apply. Um, Before people are eligible for a Centrelink payment. There's a number of different waiting periods, and they depend on really the individual circumstances. So the first one we've got here is the newly arrived residents waiting period. This typically applies to someone who's recently arrived in Australia, a newly arrived resident. Um, Normally it applies from when they've arrived in Australia, if they've been granted a visa onshore, the date the visa was granted. Um, It's a period of time they normally have to wait before they're eligible to receive a Centrelink payment. Only time spent within Australia counts towards this waiting period as well. So, for example, if someone um, is serving a newly arrived residence waiting period, they travel overseas on a holiday for a couple of weeks, those weeks that are outside of Australia won't count towards their waiting period. In 2019 as well, these waiting periods were increased. Originally, the maximum for most payments was 2 years, and that was doubled up to 4 years. So it's a long period of time people have to wait before they're eligible to receive any support from Centrelink. And often it can give rise to problems. So, for example, if someone has been working in Australia and they lose their job and then they lodge a claim for an for a Centrelink payment, sorry, they might be rejected because of a newly arrived residence waiting period. We see situations well where people might be in family and domestic violence relationships um, and leave a relationship and are concerned about whether or not they're able to access a Centrelink payment because of this waiting period. Or it can be all sorts of other things, some sort of significant change in circumstances in someone's life. There are some positives though. Um, this waiting period doesn't apply if you're a citizen. There are some exceptions as well for people who are refugees or former refugees, and sometimes family members of refugees. And family members, a partner, dependent child, or a person who should be treated as if they were a partner or dependent child. There's also some subclasses of visas that are exempt from the waiting period as well. Excuse me. On top of that, too, there's a specific exemption for a payment called special benefit, that payment of last resort that I briefly touched on earlier, where you might be exempt from the waiting period if you've suffered what they call a substantial change in circumstances outside of your control since coming to Australia. So, for example, if Yuriko in that case study that I showed earlier, if she'd had a permanent visa or a visa that was eligible for a Centrelink payment, but was serving a newly arrived residence waiting period, due to the family and domestic violence that occurred, it's possible that she might have been exempt from the waiting period for special benefit. Unfortunately, though, this exemption doesn't get around that visa eligibility issue, but you need to be on um, sort of the right visa to be eligible for a Centrelink payment to begin with. And so we've got a list here of these newly arrived residents' waiting periods. So, for example, there's no waiting period for Family Tax Benefit Part B and childcare subsidy. It's a 1 year waiting period for Part A and carer allowance, 2 years for carer payment, parental leave. And then for most other Centrelink payments, it's 4 years. Additionally, there's what they call the qualifying residence period. It's actually a 10-year waiting period. You need to be an Australian resident for 10 years before you're eligible for the age pension and the disability support pension. So that can pose an issue, particularly for someone who might be a newly arrived resident. Perhaps they've been in Australia for 5, 6 years, and have reached age pension age. They might not be eligible for the age pension because of this 10-year qualifying period. And so it's possible they might be eligible for something else like special benefit, for example, because they're not eligible for any other payment. And like I touched on earlier, there are other exemptions as well for people who are Australian citizens. If you're a citizen, you don't have to serve this waiting period. If you're a refugee, former refugee, or family member of a refugee, you should be exempt. There are some limits, though, to how that applies, particularly for family members. You need to have been a family member of that person who became a refugee at the date they became a refugee and at the date you lodge a claim for a Centrelink payment. They're two crucial points in time that you need to meet for that exemption for family members of refugees to apply. And so, with that in mind, we've got another case study here. Amaya was referred to our centre by her school counsellor. Her family had been struggling, living off just her dad's New Start or now job seeker payment alone. She'd lodged an application for youth allowance, but she was rejected, and Centrelink told her that she couldn't get a payment for 4 years because she'd only recently arrived in Australia. I think it was within the last 6 to 12 months that Amaya had managed to arrive. Her dad had come to Australia some time earlier, approximately 10 to 15 years earlier as a refugee, and it had taken the family that long to finally be reunited. Amaya was 19 when she finally arrived in Australia to live with her dad, who'd come here about 10 to 15 years earlier. He'd arrived here as a refugee and he'd been granted a protection visa after he'd been released from immigration detention. Because her dad held a protection visa and Amaya was a family member of a refugee, specifically a dependent child of a refugee, we contacted Centrelink and advocated on her behalf. We argued that she was a family member of a refugee, a dependent child, and that she'd been financially dependent on her dad, particularly during the period of time where they'd been separated as well. Once dad was able to, he'd begin sending money back to his family to help support them. Centrelink had failed to recognise as well that she was a dependent child and had incorrectly rejected her application for a payment because of this 4 year waiting period, the newly arrived residents waiting period. We argued that that shouldn't have applied to her. Um, Centrelink overturned their decision to reject her application for a payment, and Amaya was granted and her application had been back paid. There's a number of other common waiting periods that can apply for Centrelink payments as well, so they don't just apply if you're a newly arrived resident. Typically, there's an ordinary 1 week waiting period when you apply for a payment. So you've normally got to wait a week before you start getting the payment once your application's granted. There's also what they call the liquid assets waiting period. This goes for a maximum of 13 weeks and can apply if your liquid assets, if your cash, savings, shares, etc., are over the relevant threshold. For a single person, it applies if your savings are over $5,000, I believe. It doesn't apply to every payment as well. There's some payments that are exempt from this. Another one that can apply is the income maintenance period. There's no maximum period of time that this one actually applies for. So it can go for weeks, months, years. Really, it depends um, on the termination payment or redundancy payment someone receives when they leave work. So this specifically applies if you've left work and been paid a lump sum termination, redundancy, pay out of your long service leave. Um, these ones can be quite difficult to navigate in particular. As well, you might have to serve what they call a compensation preclusion period if you've received lump sum workers' compensation. So if you've received workers' compensation and there's any amount in there for economic loss or lost earnings, Centrelink might apply one of these preclusion periods. These are a number of weeks or years that people are precluded. They're not eligible for a Centrelink payment because of the lump sum workers' compensation. It can also apply, for example, if you've received compensation from a car accident. This one applies to most Centrelink payments. There's some exceptions though, like childcare subsidy or family tax, I believe um, normally it's only taken into account for approximately a year. As well, there are waiver rules for each of these waiting periods, but they are all quite different. So, for example, a compensation preclusion period, if you can't get a Centrelink payment for a number of years because of lump sum workers' comp, that can be challenged and possibly waived if you've got special circumstances. Special circumstances is broad, it's not sort of specifically defined within the legislation. Whereas this other one, the income maintenance period, if you've received a lump sum termination payment, that can't be waived in special circumstances. That rule doesn't apply. Instead, it's if you're in severe financial hardship, and there's a number of other qualifying rules for it as well. All this to say that, you know, if someone applies for a Centrelink payment and they're told that they're not eligible for a number of weeks, months, years, it could be any one of these waiting periods that could apply. If they're a newly arrived resident, it might be that newly arrived resident's waiting period. Um, if they've got some savings, it might be this liquid assets waiting period. If they've recently left work, could be the income maintenance period. Or if they've received lump sum workers' compensation, it might be a preclusion period. All right, but we might stop there for a couple of questions.
Thanks, Julius. We do have a couple of questions in the chat. So I guess the first one is it was in regards to DSP. So um, if both parents work and earn a reasonable amount and a child with ID, I think maybe that's intellectual disability, does the parent's income have an effect on DSP payments?
Yeah, that's a really good question. Um, Parents' income normally does apply to the disability support pension if the child's what's essentially considered dependent. Um, Normally, they're only exempt from that if they're sorry, a bit of a roundabout way to answer it. Normally, they're only exempt from that if they're considered independent, sorry. So, for example, once you turn 22, your parents' income isn't taken into account. So yeah, normally the parents' income should be assessed for whether a young person's eligible for the disability support pension.
Thank you. And then another question we have is, are there rules around supporting evidence? So, for example, can Centrelink request a mortgage contract if you have submitted mortgage statements?
Um, they do have very, very, very broad information gathering and requesting powers. I don't know that they'd request a mortgage statement in particular, or the contract of your mortgage in particular. Um, but there are all sorts of documents that they can request, and depending on the section of the Act that they request that information under, if someone doesn't comply and provide those documents, Centrelink can suspend or cancel people's payments as well.
Great. Another one we have is, how can we help clients with job seeker exemptions, even if it's temporarily, if they are not actively linked in with a GP?
Yeah, there's a number of different exemptions that can apply. I think it largely, like a lot of other things here, depends on the individual's circumstances. Like, for example, if someone's homeless, you know, they could be exempt from having to meet their job search requirements. I think it depends on, who you are and what your role is as well. If you're a social worker supporting someone in those circumstances, perhaps you might be able to write them something like a letter of support setting out what they've gone through so they can give a copy to Centrelink and ask to be exempt from their job search requirements. With the medical exemptions, that's a lot tougher because you do need a GP to complete the medical certificate form to be exempt.
And one last one is, do you try applying for the age pension first to show rejection before applying for special benefit?
Just sort of thinking that through. Um, it depends on the person's circumstance. Let's say it is someone who has, not been in Australia for 10 years and hasn't been a resident for 10 years. They could actually apply for both at the same time. Apply for both the age pension and special benefit. If they're clearly not eligible, though, it'd probably be best to just apply for special benefit. But there's nothing preventing people from lodging applications for multiple payments at the same time. Another somewhat analogous example is, let's say, the disability support pension, that has a 10-year qualifying residence period as well. Um, Even for people who don't have to meet that 10-year residence period, we often recommend people, if they're not receiving any payments and want to apply for the DSP, to apply for both that and job seeker payment. Disability support pension can take months for a decision sometimes. And so, getting on job seeker at least means there's some form of income coming through.
We have a few more questions rolling in. I'm not sure if you want to sort of address them now, or we will. Some of the questions that you guys have popped in the chat, we will get around to showing some slides on some of the things that you guys have asked for. So hopefully some of the questions will be answered as the presentation sort of goes on. But I might,
Yeah, I
yeah,
might take one more,
yeah.
if that's all right, Alentia, and then we'll keep going.
Okay, great. So, this is sort of a statement with a question. So, I've heard mixed things about clients on visas and their different eligibility for CCS. Is a client on a visa eligible for the CCS and ACCS?
Um, Sorry, I have to think it through a bit. The CCS rules, particularly how they interact with the visas and visa requirements, are quite complicated. Um,
Mm.
Julius, I think there's an exceptional circumstances
yeah, and it's sort of
for
this special
childcare subsidy
circumstances way around
um,
childcare subsidy in particular.
that if the person's not otherwise eligible because they're not a permanent resident, they're on some kind of temporary visa, as a discretion on the
Mm,
part of Centrelink, they might be able to get childcare subsidy,
yeah, I think
even
it's
if
one
they're
of
on a
these
temporary
rules that
visa.
are quite difficult to get applied, and something you need to be quite proactive in requesting as well. It's something that they don't sort of ordinarily consider day to day.
Okay, great. Yep. Thanks, Julius. That's it for the questions for now, and then there'll be an opportunity to ask questions again.
All right. And so, um, excuse me, depending on what Centrelink payment someone's receiving or what they've applied for, they might have to meet what are called mutual obligation requirements. So these are typically engaging with a job agency, meeting a number of job search or points requirements throughout the month to continue to receive their payment. These normally apply if you're receiving job seeker, youth allowance as a job seeker. So if you're under 22 and looking for work, it can also apply to people who are on the disability support pension that are under 35. The mutual obligation requirements for disability support pensioners under 35, though, can be quite different. For example, it can include things like continuing to engage with your treating medical professionals, going to your psychologist and counselor's appointments, things like that. For most people, though, it's doing things like engaging with a job provider, going to appointments with them, signing up to a job plan and meeting your requirements within that. Um, like I've said, attending appointments, looking for work, applying for jobs, and then accepting any offers of what they call suitable paid work. You don't have to accept Every job there are some that might not be deemed suitable. Again, it can depend on the individual circumstances. It can be quite complicated and difficult to navigate though. A lot of problems we see pop up as well include things like if people have been suspended for not meeting their job search requirements, if people are unwell, not able to look for work, um, and sometimes the uneven policing by job search providers. There are a number of exemptions that can apply to these job search requirements, and some of them I briefly touched on earlier. So they can include if you have a temporary medical incapacity. So this is where you go to your GP and get them to complete a medical certificate. Normally, it's only granted though if you've got a temporary incapacity. So it means if your condition isn't permanent. If you've got a condition that they say is permanent, Centrelink will normally tell you to apply for the disability support pension instead. This can create what feels like a bit of an anomaly, a bit of a gap that people fall through where they might be too sick to look for work and be able to meet their job search requirements. And their condition might be permanent, but they might also not be severe enough to be eligible for the disability support pension. Um, and so with this temporary incapacity, Centrelink can grant them if you've had a flare up or exacerbation of a permanent condition. So you've got an existing condition, but it's temporarily worse. Some of the other circumstances where people might not need to meet, might be exempt from their job search requirements can include things like, the bushfires, floods, national emergencies that have been happening. Um, for example, with the floods up in Port Macquarie, Lismore, Tweed, places like that, normally there'll be a blanket sort of exemption from mutual obligations that might apply. Um, as well, people's individual circumstances, if there's a family crisis, if someone's experiencing family and domestic violence, or perhaps they've just escaped family and domestic violence, if someone's homeless, they might be exempt from their job search requirements. Some circumstances involving care of children. Um, as well as, something like sorry business. If you have to attend sorry business, not able to meet your requirements, you might be able to be exempt as well. And so with that medical exemption side of things, we've just got another case study here. So Nisha has been suffering from long-term clinical depression. Her mental health has deteriorated quite significantly over the last couple of weeks. It's gotten to the point where she's, having trouble eating. She's going through bouts of insomnia. She's not able to sleep. She's extremely fatigued and tired all the time, and she's started to experience suicidal ideations. Um, she went to a GP and got a medical certificate saying that she wasn't able to look for work and couldn't meet her job search requirements for the next 2 months. Because of how long she'd been suffering from this condition, Centrelink rejected her medical certificate and told her that the condition was permanent and that she wasn't eligible for a medical exemption. Um, we spoke to Nisha about it and had a look at her medical certificate and saw that it said that her condition was permanent. Her condition hasn't normally been this severe. We recommended that she go back to a GP and speak to them about her condition, whether it has been exacerbated. She went and did that, and her GP wrote a new medical certificate, which she provided to Centrelink, and they accepted and granted her exemption. All right. Well, we might just stop there for a short 5 minute break. Um, we'll be back at in 5 minutes at 3 past 3. So just an opportunity to get up, grab a glass of water, stretch your legs. Um, I know these presentations can sometimes go for a while. All right. Thanks, everyone. We'll be back in 5 minutes. All right. Excuse me. Might just give it another sec for people to get back. All right, and we'll continue going along. I think enough people should hopefully be back now. All right. So something I've touched on as well throughout the session is there are a lot of Centrelink payments that are affected by people's income and assets. So most Centrelink payments do have assets tests and income tests. Um, the assets tests set out the amount or value of assets people can have and be eligible for most Centrelink payments. There are different assets tests between income support payments like job seeker and youth allowance and the assets test for pensions, for example. So, for example, with job seeker payment, it's got an assets limit, and once you reach that limit with the value of your assets, your payment's cancelled, you're not eligible. Whereas with the disability support pension and age pension, instead it's got a point your assets can reach where once you're up to that point, your pension is reduced up until you reach this second cutoff point. So with the table on the left, we've got that first point. For a single person who owns their own home, they can have $321,500 in assets, and then once their assets reach 704,500, then their age pension would be cancelled or cut off. So, for example, if someone has reached age pension age and they've got an incredible 800 grand in super and they own their own home and they apply for the age pension, they might be rejected because their assets are over the cutoff limit. And so, like I said, there's, with job seeker, parenting payment, payments like that, once your assets reach the limit, it cuts off. But with pensions like the age pension and disability pension, it's got a first point you reach and the payment rate starts to taper down up until you reach this cutoff point, which is on that second table on the right there. They're quite generous for pensions as opposed to other payments. Um, Assets can include things like, your household contents, cars, caravans, boats. Something I often ask clients when I'm talking through about their assets is whether or not they've got a Ferrari in their garage or, you know, what the value of their car is. Um, if someone owns real estate, so if they've got investment properties, if you own your own home and you're living in your own home, it's not normally counted towards that assets limit. It's normally exempt. There are some exceptions to that, like if your home is on a block of land that's more than 2 hectares, then the amount over 2 hectares could count towards your assets test. So that becomes a particular problem for farmers or people that might live on rural acreages or plots that are um, several hectares large. Um, As well, assets can include things like businesses, possibly the assets of the business, depending on if all of that business is applied to you. Um, Crypto, savings, gold, shares, etc. A problem can come up if someone gives away their assets. It's what they call disposing of their assets without any adequate compensation or anything in return. So, for example, if you give your children 100 grand for a deposit for their mortgage, Centrelink would likely count that as a gift. When someone gifts money or assets to someone else, there are gifting limits. You can normally gift up to 10,000 in 1 year, or 30,000 over a rolling 5 year period. Once you gift over 10,000, the remaining amount over that 10,000 counts towards your assets test, normally for the next 5 years. So if someone gifts their kids 110 grand, 10 grand would be exempt from the assets test, and the remaining 100 would count towards their assets test as a gift. Like I said earlier, there are some assets that are exempt from being assessed. So, for example, if you live in your own home, um, and you own your own home and it's under 2 hectares, it's normally exempt from being assessed. So you could have, a waterfront mansion in Sydney Harbour, and as long as you're living in it, it wouldn't count towards your assets test. Some problems that can come up with assets in Centrelink can include things like people dispute ownership of their assets. So for example, if, someone's bought a property um, 50-50 with another relative, um, could include things like if you can't sell your assets, maybe you own a rundown shack that you're not able to sell that wouldn't be worth much on the open market, but Centrelink have said that it's worth enough to affect your rate of payment. There are what they call asset hardship rules that people can apply for to try and get the value of an asset like that disregarded. There are specific criteria that they need to meet, though, for that to apply. They normally need to be in first severe financial hardship, and then second be unable to, or it needs to be unreasonable for them to sell or borrow against the asset. Circumstances where that can come up can include things like if someone's left a family domestic violence relationship and they jointly own the family home with the perpetrator, and maybe the perpetrator stayed in the home, doesn't want to sell, um, it's possible they might be able to apply for asset hardship to get it disregarded in those circumstances. Problems can also come up if people haven't told Centrelink about their assets when they apply for a payment, um, especially if Centrelink become aware at some point in time in the future, they can raise a debt. As well, people often dispute what Centrelink have valued their assets as. This happens often with, real estate and property. Centrelink might value it as one thing, but the reality might be, like I said earlier, with that rundown shack example, that a person sees it as valued a lot less because of its condition. Most Centrelink payments have income tests as well, so normally people's income affects the amount of payment they can receive. There's a number of different factors that can influence this, though. It can include things like someone's age and whether or not they've got dependent kids. When people are reporting their income, they always need to report the gross amount, so how much they've earned before tax. Um, for a long time, this has been something that's tripped people up with reporting, and it's something I've seen many, many times. People who didn't know they needed to report gross were reporting the amount of money they actually received in their hand from work, and then get a bit of a shock some weeks, months, years later when Centrelink say they've been overpaid. For most Centrelink payments, you need to report your income fortnightly as well. Um, there's some exceptions to that, like if you're a sole trader, you might be required to report fortnightly and quarterly, and provide profit and loss statements for your business to Centrelink. Other payments like family tax benefit, though, it's got its own complicated reporting system where people estimate what their family's income is going to be throughout the financial year, and then Centrelink compare that in this reconciliation process where they look at the figures from the ATO and how much the person's actually been paid and what they estimated they were going to earn throughout the financial year. Um, you can update your estimates throughout the year, but this is quite different to the fortnightly reporting for parenting payment. I've seen many situations as well where people have been reporting their family's income for family tax, but not reporting their income every fortnight for parenting payment. And these family tax benefit reporting and parenting payment reporting systems don't speak neatly to each other. They don't cross-communicate with how much you're earning every fortnight. And so it can mean that if you don't report for both, people end up with Centrelink debts. Just an example of the income tests that can apply as well. So for example, with job seeker payment, you can earn up to $150 before your rate of job seeker is affected. Then once you earn over that, it reduces by 50 cents for each dollar from 151 to 256, and then reduces 60 cents in the dollar for each dollar over 256. If you're on job seeker and you're a single person and you're a principal carer, so if you're caring for children, it's a different income test. It doesn't affect your payment the first $150, and then for every dollar you earn over 150, your job seeker is reduced by 40 cents. Um, just to further show how complicated the reporting and income tests can be, there's a number of different income tests that can apply. Not all of these figures are current in this slide. This one's more of just an illustration to show, the number of different income tests that can apply for people depending on what payment they're getting and their individual circumstances. So income reporting itself and the income tests can be complicated. But really, the important takeaways are that people need to report their income and make sure they report what they're earning before tax, not after tax. These income tests as well, they are available on Centrelink's website, so you can have a look. If you're searching Google job seeker income test, you can find this information, and it is set out in these tables like this. It's pretty accessible. Like I've alluded to, some of the problems that can come up with income can include if people haven't declared or have under-declared their income, um, if they've declared net instead of gross, um, if they're in a relationship and they haven't declared their partner's income as well. People need to declare what their partner earns too, not just their own income. As well, things like Robodebt, where Centrelink averaged and apportioned people's income and the income apportionment case that's happened recently. Um, just another heads up, there was a recent change. Sorry, this is a bit outdated now. It's from a while back now where there was a change with how income was reported. It's declared when you've received it rather than, I guess, estimating how much you're going to earn throughout a fortnight. And here's just a bit of a plug for Centrelink's financial information service. This is a service that Centrelink run that can be very helpful when trying to figure out some of the complicated situations with assets in Centrelink. Where I think this can be particularly useful is, for example, if there's a situation where someone's got a trust and they're not sure how that's going to affect their Centrelink payments, or they might have interests in businesses. This is a really valuable service that Centrelink offer. They can provide some information on how assets can interact with people's payments. Another thing that can affect your Centrelink payments is whether or not you're in a relationship, whether you're what they call a member of a couple. So whether or not you're a member of a couple determines what payments you can get and the rate of the payment you can get. There's lower rates of payment that people can receive if they are in a relationship than opposed to if they were single. As well, for example, with determining what payment someone can receive, um, if you've got care of children and you're applying for parenting payment, there's two separate versions. There's parenting payment single for people who aren't members of a couple, and there's parenting payment partnered for people that are. Centrelink had the same definition of what a member of a couple is across all Centrelink payments. This is under the Social Security Act. And they look at these 5 factors when they assess whether or not someone is in a relationship. It's not a black and white thing. There's a number of things they take into account. This includes things like the financial aspects of a relationship, whether people pool their money, and work together as a couple financially, the household, whether people live together, whether they, sleep in the same bedroom or if they've got separate rooms, whether someone holds themselves out as a couple, whether friends and family know that they're in a relationship or if they think they're single. Um, where we see this often being a problem, this member of a couple assessment is where people um, might be living under the same roof with an ex-partner, living what they call separated under the one roof. Um, Essentially, we'll also look at things like, whether there's any sexual relationship, as well as whether there's any ongoing commitment, the nature of a relationship, and whether the people are committed to each other. Through some of our advocacy with Economic Justice Australia, there have been some changes to Centrelink's Social Security Guide as well to better recognise family and domestic violence, particularly in assessing whether or not someone is in a relationship. So, the presence of family and domestic violence in a relationship might show that um, it's a relevant factor that should be considered and might show that someone isn't actually a member of a couple. They're not in a relationship due to the nature of what they're experiencing. As well, this is a subjective test, so it's not a, you know, neat tick box one size fits all. It depends on the individual's circumstances and how they interact with those 5 factors. Some of the problems we see come up can include um, relationships are complicated. It might not be clear whether or not someone is in a relationship according to those 5 factors. The way I often describe this to clients is it's trying to apply, the neatness of these 5 criteria under the law to the messiness of people's lives and how they interact in their relationships with one another. As well, it might be tricky when someone's in an on-off relationship. I think particularly with family and domestic violence, it's often the case that it takes several attempts before someone is able to finally leave the relationship. Um, Other problems can include if people aren't correctly declaring their partner's income or don't know what their partner's earning. Perhaps there's financial abuse, or where people haven't told Centrelink that they are in a relationship, and they've been coerced into doing so. Like I touched on earlier as well, um, Centrelink can consider people to be separated but living together under the one roof. Um, this is something that we see happen relatively often. Normally, in these situations, though, people need to explain to Centrelink why they are still living together and provide evidence about, their relationship and whether or not they are in a relationship. Otherwise, Centrelink will treat them as being a member of a couple. Where there is family and domestic violence as well, we found Centrelink social workers can sometimes be invaluable and having a chat with someone, talking about what they're experiencing as well, and making a recommendation, but they're not in a relationship. A problem that we see happen as well with people who are separated under the one roof could be where someone's lived separated for years. We've seen situations where people have lived with an ex-partner for 10, 20 years. Often it might be because they wouldn't be able to afford to move out or live by themselves. Centrelink can review whether or not they think someone is separated and can make a decision and perhaps even change the decision, deciding that after a period of time has elapsed, that they do think people are in a relationship again. Um, Something I will touch on a bit later that I'm just going to give a heads up on too, is that people can appeal or ask for a review of Centrelink decisions. So Centrelink deciding someone is in a relationship, that is reviewable. And so we've got another case study here. This one's a video. Um, Alantia, can you just give me a thumbs up if the audio works?
Hi, Daniel. Yes, it's Maria. I am just hoping you can help me with something today. I've received a letter from Centrelink and they're asking me about my relationship. and I'm just wondering why they're hassling me.
Oh, okay. So can you tell me, do you live with your partner?
Now he's my ex-partner. We haven't been together for about 4 years now, but we're still living in the same house. I have let Centrelink know that I had an appointment with a worker there and let them know about 4 years ago that we were separated.
All right. So what payment are you on at the moment?
I'm on the disability support payment.
Sure. And do you get the single or the couple rate?
It's the single rate.
Okay. So Centrelink does review things from time to time, and they have a number of criteria to assess whether or not you're a single person or a member of a couple. So I'd just like to ask you some questions to get a picture of your circumstances.
Sure.
So can you tell me a little bit more about your living situation? Do you have children?
Yep, we've got 3 children. They're a bit older now, but 2 of them were living away from home, but they've had to come back because of everything to do with COVID. So they have returned home. But they know, they know everything about my ex and I. We let them know when we were separating. So they're very aware of the situation.
All right. And what about other members of the family?
Yep. When we decided to separate, we did tell everybody. So yeah, it's been very clear about that.
And do you still do things with your ex-partner's family?
No, not at all. Yeah, I have my friends and I don't have anything to do with his friends or family.
So can you tell me a little bit more about why you've chose to remain living together?
Really, it was to do with just being able to afford to live there. If we were to sell the house, I don't think I would have been able to get back into the market. And for me, I had to find somewhere suitable for my disability. I need no stairs, wide entrances for my walker. So yeah, that we just couldn't find anything that was in my price range. So that's why we've decided to stay.
Okay, and is there a mortgage on the property?
Yes, there is.
And is that in your name or your ex-partner's name or both?
No, it's in both of our names still. We just pay half each. Just the cost of getting another loan. We just pay half each every month. So
okay. In terms of the children, who do the kids eat with?
I guess sometimes they eat with me, sometimes they have dinner with him, and very rare occasions we might have dinner together, but that's very rare.
Okay. And you mentioned that you had a major back injury.
Yes.
Does your ex-partner assist you anyway with your mobility issues, or?
No, not at all. I get myself around and to my appointments, I do that myself. Yeah.
Right. And do you know if you've given authority for the doctor to talk to him about your care, or whether he's listed as a next of kin or emergency?
I think he actually still is listed as that.
Okay.
Yeah, I just didn't want to burden the kids with that, so I've left that as is. And he knows a lot about the information about my accident, so.
All right. So that was a situation that we probably see pretty often where, a couple have separated, have continued to live together under the one roof, and Centrelink have reviewed that and looked at whether or not they think they're still in a relationship or in a relationship now. So with those 5 factors, Centrelink look at the financial aspects of a relationship, the accommodation, the nature of a household, the social aspects, whether they hold themselves out as a couple, sexual relationship, and the ongoing commitment. Are they in a relationship currently? There's some factors for and against, considering whether they're separated, towards them being separated, family are aware they're not in a relationship, children know, extended family know, they don't hold themselves out socially as a couple, they don't go to family events together, they don't socialize together, everyone who knows them knows they're separated, with the way the household's set up as well, they do their own shopping, do their own cooking, have separate meals most of the time, sometimes meals together, but not too often, may sleep in separate rooms. There are some factors that go towards them being in a relationship that Centrelink would consider and probably place some weight on as well. So, for example, with the financial aspects of a relationship, they still have the mortgage together, they're still somewhat financially intertwined and to pool their resources together. As well, there's some ongoing commitment or reliance on one another, and that they still live in the same house to support the client's disabilities. Um, it's a tricky situation, but I guess I wonder whether this might be something that continues to happen and maybe comes up more and more with the cost of living and with people being unable to move or live on their own. With relationships in Centrelink, we do have a fact sheet as well that goes through the factors Centrelink look at. We've got a section on our website and a link as well to Economic Justice Australia's fact sheet on relationships in Centrelink. This goes through a number of factors and questions that we tend to go through as solicitors as well when we're speaking to someone to assess whether or not they are in a relationship with Centrelink. Um, it is a subjective test, like I said earlier. So, again, it's the messiness of applying the law and these factors to people's relationships. This goes through with questions about, the financial aspects, the accommodation, the social aspects, etc. Within Social Security law as well, there's a discretion where Centrelink can treat people as single if there's special reasons to do so. So this might be where someone is in a relationship, but there's some sort of special reason that Centrelink should treat them as being single instead of being partnered. If this discretion's applied, the person would be paid the single rate of payment instead of a coupled rate. So what this requires is that there's some sort of special reason to treat someone being paid at the single rate or not being considered to be in a relationship. Um, it can be quite difficult to get applied. Normally it requires that there's some sort of inability for the couple to pool their resources together, and normally they need to be in financial hardship as a result of their circumstances. So, for an example, could be if one member of a couple's living overseas um, or can't work and isn't eligible for any Centrelink payments. It's possible that Centrelink could apply this discretion to treat the person who is getting a Centrelink payment as single for the Social Security Act and pay them the single rate of payment. Something that can be a bit of a problem, though, it's trying to decide whether to um, argue that someone is or isn't in a relationship instead of asking for the discretion to be applied. All right, but we might stop for a couple of questions again. Just want to put your questions in the chat.
Yeah, so we have a few, Julius. Um, so the first one is, how do we advocate for young people that have needed to escape family violence perpetrated by parents? Is there any way that professionals can support young people without needing to be listed as a nominated person?
Um, yeah, I think depending on the young person's circumstances, right? Like if they're applying for a payment and they've had to leave the household due to family and domestic violence, they'll want to be applied to be treated as independent rather than dependent. So that way their parents' income isn't taken into account for essentially assessing their payment. In those situations, I think, again, depending on your role, if you're like a social worker, support worker, community worker, I think helping write them letters of support about, the nature of the events that they've experienced, can be really helpful. As well, I think helping to gather bits and pieces of evidence, like for example, if a young person's in the care of a minister, if there's supporting documents around that, that can be really helpful to provide to Centrelink as well to show what's happened. Other things can include providing copies of AVOs.
Thanks, Julius. And then the next one is, are legal costs taken into account when calculating preclusion periods in relation to compensation payments?
Not normally. They're normally included within the whole lump sum that Centrelink assess, which if you've paid, if you've had a settlement, there's a 500 grand settlement, but yet, you know, 200 grand's paid in legal fees, it can be quite unfair with how Centrelink calculate the preclusion period. Um, it is something that could be argued in the special circumstances side of things if someone wants to appeal their preclusion period and try and get it reduced. But again, special circumstances is discretionary, so it is up to the decision maker about whether they agree or not too.
We have had two questions just in relation to New Zealand citizens being able to apply for a Centrelink benefit. So one question was, my client is on a New Zealand passport and has worked here for 20 years but cannot claim any benefit. Is there some way that she can be helped?
Yeah, the social security system in Australia is really tough with New Zealanders. Normally, if you're a New Zealander and you weren't in Australia on the 26th of February 2001, sorry, I've got that date on my board next to me. Um, Normally, if you weren't in Australia on or before that date, then you're what they call a non-protected special category visa, and Centrelink really limit the payment someone can receive. They're pretty much limited to job seeker or youth allowance after they've been in Australia for 10 years, and then they can only get those payments for 6 months. I can see there's a question from Giselle. It's the 26th of February 2001. So they normally need to have been in Australia for 10 years and then they can only get job seeker or youth allowance for 6 months. The only other payments they can possibly get, we've got what's called an international social security agreement with New Zealand. And under that, people can get the age pension, disability support pension in very limited circumstances. They need to have a severe impairment. It's quite a threshold to meet. Or they might be eligible for carer payment, but only if they're caring for a partner who is receiving the disability support pension. So yeah, it's very, very tough for New Zealanders to access Centrelink, particularly if they weren't here on or before Feb 2001. Um, there were recent changes for citizenship. I know it can be costly to apply for citizenship, but if they do become an Australian citizen, they don't have to serve, that newly arrived residence waiting period. They're exempt from that. They might have the qualifying residence period for age or disability pension, but depending on the agreement as well, time in Australia and New Zealand might count towards some or all of that. Um, but without citizenship, it's, yeah, really limited for New Zealanders in Australia. If there's, a community legal centre that specialises in immigration law and that person's able to get some advice from them, I'd really recommend it. For example, in New South Wales, we have IARC, the Immigration Advice and Rights Centre.
Thanks, Julius. This one is in relation to income and assets. So, what happens if you cannot live in your house due to an ABO being in place? Does your house still count as an asset?
Um, it's a good question. And I think it somewhat depends as well on who you are in the ABO, whether you're the person in need of protection or if you're for lack of a better word, the perpetrator. Sorry, I don't work in criminal, so I'm not sure of the exact terms that they use. Um, there are periods of time where Centrelink can exempt the house from being assessed as an asset when you leave. I've never come across this scenario before, particularly if someone's, allegedly the perpetrator and how that would interact. Um, it's possible it'd be able to be exempt. Normally it's for a maximum of 12 months, sometimes 24, but it can be difficult. Um, yeah, I think, to cut it short, I'm not 100% sure how that would work, where someone is the perpetrator. I've typically seen that scenario happen where it's a, victim survivor of domestic violence that's left the home and has a joint interest in it.
Thanks, Julius. And this question is sort of related to the one that you just answered. So, does domestic and family violence, the asset exemption, apply to all assets jointly owned or just the primary home?
It's normally just for primary home. Um, but I can see that it can be messy, particularly with how financial abuse can occur as well, where, for example, a perpetrator might appoint the victim as a director of a company or of several companies and might set up trusts. And, often it can be a really huge mess to try and untangle.
And if we have time for one more.
Yeah, absolutely.
So if a client is experiencing domestic and family violence and financial abuse, but the partner was the carer um, and receiving carer payments, if the client spoke to Centrelink to let them know that he's no longer the carer, Centrelink has advised that they cannot remove him. What can they do to remove that person as a carer?
Hmm. Um, Look, I think if it's a family and domestic violence situation, I'd definitely recommend the person maybe consider contacting the complaints line and speaking to a social worker at Centrelink. Um, because I can say it'd be particularly problematic if they do leave as well, if that person's still the carer and or receiving carer payment, and particularly if they're the person's nominee for Centrelink, there'd be safety concerns as well that could come up if they receive letters from Centrelink that show where this other person's living. All right, but I might keep going, everyone. And so another factor that can impact what payments a person's eligible for, the rate of payment, the tests that can apply, etc., can include whether or not people have kids. So, things like the number of children someone has, the age of their kids, where the children are living, whether or not the children have disabilities, etc., can affect what payment a parent is eligible for. For example, whether it's parenting payment or family tax benefit, or job seeker with a dependent child. The conditions of a payment, for example, whether or not they need to look for work. If you're on parenting payment, there's job search requirements that can apply depending on how old your kids are. As well, kids can impact or influence the rate of payment someone receives. So, for example, if they um, share parenting with an ex-partner or a co-parent, the percentages that the children are in either parent's care can influence the amount of family tax benefit they're eligible to receive. Some of the problems that we see pop up as well can include changes in these percentages of care. Um, I think in particular as well, the interaction between the family tax benefit system and child support. Um, Excuse me, I don't really have any expertise or much knowledge in the child support system, but it does have flow-on effects, child support's assessments for family tax benefit, what Centrelink assess the level of care or care percentages as well as the amount of family tax someone can receive, can depend on whether or not they're receiving child support from the other parent. Other problems can include if, people dispute the level of care that's being provided to the children or the percentages of care. Um, like I mentioned earlier with the income tests as well, there's different income reporting for parenting payment as opposed to family tax. Parenting payment, you report your income fortnightly, whereas with family tax, particularly if you're receiving it fortnightly, you need to give estimates about what your family's adjusted taxable income is going to be throughout the financial year. Um, and if you're reporting for family tax but not for parenting payment, there could be a risk of a debt if that income's not being taken into account or being taken into account for one but not the other. Something that can cause issues as well, and something that we see every now and then, it's where children have been, taken by one parent and not returned to the other without their consent. And perhaps some period of time has gone by with the children out of that person's care. Centrelink can become aware, perhaps when the other parents lodged a claim for a payment and then contacted the initial person and said, the kids have been out of your care for some time, you weren't eligible for a payment and raised a debt. Um, with that in mind as well, there's a little reminder at the bottom that with Centrelink payments, people have an obligation to advise of any changes in circumstances within 14 days. So that includes things like, whether or not are in someone's care, whether they've left, if they've been taken, etc. Like I've alluded to a couple of times as well, it's a complicated system with different intersecting payments and different conditions around them. Like parenting payment, it's only paid to one parent, even if there's a shared care arrangement over the kids. Typically, it's paid to the parent, I believe the wording is, that would receive the most benefit from the payment. Or the parent, sorry, who's most disadvantaged by not receiving the payment. Whereas family tax benefit, that can be split between two parents, and the minimum percentage that a child needs to be in someone's care is at least 35%. They normally assess that as well based on the number of nights the children are in someone's care. All right, we've got another couple of examples here. So Maria and a 10-year-old daughter were living with her mum because Maria was very ill, had no source of income. She's applied for family tax, but Centrelink have told her that they can't process her application until her ex-partner signs paperwork confirming the child's living with her. She's tried to get in contact with the children's father, but couldn't. By the time she contacted us, um, she'd accumulated a lot of legal fees trying to challenge her custody issues, and they'd racked up to almost 30 grand. So she's got a bit of a complicated situation here where perhaps the ex-partner is alleging they've got some level of care over the 10-year-old daughter, and Maria's disputing that and claiming she has full-time care of the child. Another one with the percentage of care situation as well. Satar here, she left her violent relationship and took her 3 kids with her. Her husband continuously demanded to have additional time with the kids, kept threatening to stop paying child support and cut that off unless he was given more time with them. He continued to perpetuate and perpetrate that abuse, I guess, through the use of these systems. She tried to keep Centrelink up to date with changes that were happening with the amount of time the kids were with him. Um, However, there'd been some issues and some disputes around that level of care. Um, and she contacted us after Centrelink had sent her a letter saying that she owed 17 grand in family tax benefit. As well, like I mentioned earlier, you know, if children leave someone's care, they can end up with a Centrelink debt. Their rate of their payment can be affected. Tara, who again had experienced family domestic violence, had been hospitalized. While she'd been hospitalized, her children had been taken by her mother-in-law um, and refused to return them. During that period, the kids were out of her care. Centrelink said she was overpaid family tax benefit and raised a debt against her. And so flowing on from that, I'm just going to talk a little bit about Centrelink debts. Um, so first of all, as an example here, we've got a debt notice. This is the letter that Centrelink will send someone to tell them that they've got a debt, normally to be in the post or normally to be available on someone's MyGov as well. In the top right corner, you can see that amount due. That shows how much the debt is for. Under the You've Been Overpaid heading as well, we've got the time period the debt's for, 5th of June 2004 to 20th of August 2019. As well, it's for the disability support pension. And we've also got the reason for the debt. As you're a member of a couple, you're entitled to the partnered rate of payment. So presumably they've received the single rate of payment over that lengthy time period. Um, With our service and giving advice to people that have debts, these letters are particularly helpful because of the amount of information they have. It includes the amount the debt's for, sometimes the reason for the debt. Not every debt letter includes the reason, unfortunately. For example, with family assistance, family tax benefit debts, sometimes it'll just say your family circumstances have changed. Family circumstances could be anything. It could be, you know, your family's income. It could be the level of, the percentage of care of the children. Um, that can be quite unhelpful, but it's also helpful that it shows the time period that it's for as well. So it can help with trying to figure out, what's happened over that period of time. But just to take it a bit of a step back, what even is a Centrelink debt? Well, a debt under the Social Security Act occurs if a Social Security payment's been made, so someone's received a payment, and the person who's obtained the benefit from that payment wasn't entitled for any reason to obtain that. So what this essentially means is that um, a debt is when someone's been overpaid a Centrelink payment, when they've received a payment and for one reason or another they weren't entitled to receive that payment or the amount of payment they received. So, for example, that could be if you've underreported your income by accident. Centrelink might come back and say you've been overpaid the amount of job seeker you're eligible for because they didn't take into account the correct amount of your income every fortnight. There's also no time limit at the moment for Centrelink to take debt recovery action, for them to raise and start recovering debts. Um, that means that, you can see situations where I think particularly with relationships in Centrelink, Centrelink might allege that someone was in a relationship and has been telling Centrelink they were single for lengthy periods of time. I've seen debts going back to the 90s, for example. Some going back 10, 15 years. It's really incredible that there's no time limit on debts. It means that they can go back really long periods of time, um, which conversely makes it very difficult to challenge them. How do you prove your circumstances from 10 to 15 years ago? It's something we've done some advocacy on as well through EJA, Economic Justice Australia, is to try and reinstate a time limit. There used to be a time limit for debt recovery. Um, and I think, to try and stop those situations, there really needs to be one again. When you've received a debt though, the first thing we normally recommend that people do is to contact Centrelink to enter into a repayment plan or ask if the repayments can be paused or suspended. Um, if you don't enter into a repayment plan and you're getting a Centrelink payment, they can take a standard 15% of your payment and apply that to the debt. So, while we're in a cost of living crisis, rents are sky high, groceries are really expensive. To have 15% of your disability pension, for example, taken and applied towards a debt, it'd have a huge impact on someone day to day. Normally, the debt recovery line is pretty good as well with repayment plans. Often we recommend people try and get on a repayment plan as low as they can afford. Sometimes we see payment plans as low as, $10 to $20 a fortnight, and sometimes they can even pause repayments if people cannot afford it whatsoever. With entering into a repayment plan as well, it doesn't mean that you accept the debt, and it doesn't stop people from challenging it. So even though you're making repayments, you can still disagree with the debt and take action to challenge it in the future. And so, with that in mind, there's a couple of different ways people do challenge Centrelink debts. For example, this could be if the circumstances around the debt are incorrect. For example, if Centrelink allege that kids left someone's care by showing that the kids were still in that person's care. Other things could also include if the debt's been calculated incorrectly, perhaps Centrelink have taken into account the wrong amount of income, um, or something that I think we saw every now and then with Robodebt and the payroll system as well, is that sometimes employers for people who'd worked for casually might have been double counted for their income. There's also what are called waiver rules, where the review officer or the tribunal may have the debt to waive or get rid, may have the power, sorry, to waive or wipe a debt in certain circumstances. There's also what are called write-off rules, where the debt is written off as opposed to being waived. Waiver is a um, permanent action. It sort of gets rid of the debt permanently, some or all of it, whereas write-off is typically temporary. Um, with the waiver rules, the first one we normally go through is administrative error. What this is where someone's been overpaid because of some sort of error, some sort of mistake by Centrelink, and they've received the payments from that mistake in good faith. The mistake also needs to be solely Centrelink's fault, so you can't normally have contributed to that error. Where this can be a problem in particular is with the fine print on the back of Centrelink letters. So let's say, for example, you've received income protection payments from your superannuation and you haven't declared them to Centrelink, or you've advised Centrelink and Centrelink haven't taken them into account. They've sent you a letter that says you need to tell us about any income protection payments you've got. Then at that point, the onus tends to be shifted back on the person, and that sole error can end. With the good faith component as well, what that requires is that you genuinely thought you were entitled to the payments, or that you didn't question the payments you received, so you thought they were correct. This isn't a discretionary rule as well. So, under the Social Security Act, if someone's been overpaid due to an admin error and it's solely Centrelink's fault, they must waive. As well, there's the discretionary special circumstances where Centrelink or the tribunal may waive a debt if it didn't arise from the person receiving the payment or another person knowingly making false statements or representations or failing to comply with their obligations, and they have special circumstances other than just financial hardship that make it desirable to waive the debt. We've got a whole another session dedicated solely just to Centrelink debts and these waiver rules. With special circumstances, though, in that bill I mentioned right at the start, one of the proposals in that bill is to change this knowingly side of special circumstances. This can be particularly problematic for you or another person knowingly, where, for example, someone's coerced into telling Centrelink they're single instead of in a relationship, or where someone might be the payment nominee for, let's say, their adult child with an intellectual disability. The adult child starts working and the parent decides not to tell Centrelink about their income and receives their payments. With the proposed changes, although the parents knowingly misled Centrelink, it's possible that adult child might be able to get the debt waived. As it is at the moment, this knowingly side of things is a barrier for those circumstances. Special circumstances as well, it's also quite a high bar, so it is difficult to get debts waived under these rules. Not to say that it's impossible, though. It definitely happens. One of the last things as well is that Centrelink decisions can be appealed. Not all decisions should be appealed, though. Centrelink debts can increase. When an authorized review officer at Centrelink looks closer at a debt, they might go back to an earlier period in time and say that someone's actually been overpaid earlier. And so a debt could jump up. As well, depending on what someone says, they could be prosecuted. Prosecutions tend to be quite rare, but it does happen every now and then. And so just a little bit of information on appealing before we wrap up. Appeals, it can be quite simple to request. You can do so by calling Centrelink and saying, I want a review of X decision. There's also an explanation or review of decision form that people can complete. There's normally two options Centrelink will give someone, either asking for an explanation of the decision or asking for a formal review. The explanation's different. It's not actually a formal review. Instead, someone will look at the decision and explain it to the person. After it has been reviewed by this authorized review officer at Centrelink, decisions then can be appealed to the Administrative Review Tribunal. Sorry, I'm a bit tongue-tied. Just here's a bit of an overview of what the appeal structure looks like. First there's that original decision, then the internal review to an authorized review officer, and then at the moment there's two tiers of tribunal as well. If someone's dissatisfied with that, they could appeal to a federal court. Federal court's quite limited though. Needs to be some sort of error in law. The tribunal needs to have applied the law incorrectly. It's also a costs jurisdiction, so if someone applies to a federal court and they're unsuccessful, they can be ordered to pay Centrelink's legal fees, and it does happen. And with that explanation, that sort of sits between the original decision and the review officer stage. There's also time limits to appeal Centrelink decisions. With debts, there's no time limit to appeal. So, people don't have to worry about running out of time to challenge Centrelink debts. Of course, the longer you leave it, the harder it becomes to get supporting evidence. With most payments, there's a 13-week time limit to appeal. Family tax, it's 52 weeks. Paid parental leave is 28 days. There's also time limits depending on the stage of appeal. So, for example, from the first to second tier of tribunal, it's 28 days, and 28 days from the second tier to the federal court. All right, I think we've run out of time though, so I might just go through the last couple of outro slides. Thank you for attending, everyone. So a couple of takeaways. Sorry, the order here is a bit jumbled. It's one that I sort of missed when preparing this. But generally, you've got an obligation to tell Centrelink about changes in your circumstances within 14 days. Payments are normally only paid from the date that you lodge the application. It's rare, and there's very limited circumstances where it can be backdated to an earlier date. There's specific eligibility criteria around Centrelink payments as well. There's no broad special circumstances exemption. There's no sort of silver bullet, so to speak, that gets someone on a payment. As well, people can test their eligibility and apply for a Centrelink payment. It's something we often recommend clients do is if they think they might be eligible, give it a shot and put in a claim. There's also a payment finder section on Centrelink's website that's super helpful for figuring that out. Lastly, you can appeal. Not every decision should be appealed straight away. Debts can increase. We recommend people get advice before they appeal debts. All right. Like I've mentioned a couple of times, there's some helpful resources on Centrelink's website. They've also got resources in other languages. Centrelink have multilingual phone services as well that people can call. There's multicultural service officers and Indigenous service officers that Centrelink have too. People can apply to be a nominee for clients. There's digital coaching as well that goes through Centrelink's online system. More and more, the system seems to be going online. It can be really difficult for people with low digital literacy to navigate in particular. People can also phone to book face-to-face appointments in Centrelink offices. Just a bit of a plug about our service. Our intake line is open on Mondays and Wednesdays, 9:30 to 12:30. People can also lodge inquiries on our website to, get in touch to try and get some advice or information. We are a really small team and we're a statewide service, so we're not able to help everyone, but we try to where we do have capacity. And so here's the number for our intake line, 92115300, and a link to our website. The intake lines open Mondays and Wednesdays, 9:30 to 12:30. All right, and last couple of plugs. Sorry, there seem to be quite a few of these. We've got a bunch of information you can find on our website. We've got an information hub section with a bunch of resources, fact sheets. As well, we've got a First Nations section with some culturally safe resources too. We've got a number of fact sheets and online resources. As well, our sister service in Victoria has produced this Social Security Debt Help and DSP Help. They're very helpful with navigating those two issues. A bit of our social media plug. And lastly, if you're able to, we'd really appreciate it if you could complete our evaluation survey. And thank you very much, everyone, for your time. There were some fantastic questions.